Welcome back to Kapowich on Real Estate. This is a program dedicated to consumer protection within the residential real estate arena. We are pleased to have back on the program Roger Wintle, real estate attorney, and now you're the attorney for the Santa Clara County Association of Realtors.
That's correct. It's nice to see you again, Pat.
Okay, welcome back. How long have you been the board attorney?
Last 3 or 4 years.
Okay, because I've seen you speak, and I go to a lot of seminars, and when you are speaking to a group of realtors, no one gets up and leaves the room.
I won't let them.
Yeah, except me. I get up and
That's
leave.
right.
So by the way, how did you get involved with law? I know you had a couple of careers before.
Well, actually, I was a teacher in my first life.
Right.
I actually ran a private school in Connecticut before I went to law school, and then I went to law school and started practicing law. And since I've been an attorney, I've taught college courses on real estate at West Valley College to paralegals.
Sure.
And I enjoy teaching, even though I'm not teaching full-time anymore. I still have it in my blood, and I really enjoy it.
When you went back to law school, did the students call you Pops?
I'll tell you, I was not the oldest one.
Oh, okay.
I think there were a couple of guys who were career military.
Oh, I see.
And they were a little bit older than me, but yeah, we were the gray hairs in the law school, that's for sure.
Okay, so tonight we're speaking about distressed properties, specifically short sales.
Right.
And this is, of course, in the news, and now it's gone up the ladder, up the food chain. Now there's $800,000 homes, $1 million homes, $3 million homes with a short sale.
Right.
So for the audience members here, what's an easy example? I know you have a way of speaking to the audience to make it understandable. Short sale.
Well, I would say no one even heard the term short sale 5 years ago. It was something that if you said it to somebody, they'd say, what are you talking about? What it means is a property that's basically upside down. In other words, the debt on the property is in excess of the value. And so the person actually owes more money than the property is worth. Let's put it that way. It's probably a better way to put it. And so what happens is there's this concept of trying to sell your property without paying the full balance of the loans on the property. And there you get the concept of short sale, because the lenders are going to accept less than they're owed on their note in order for the transaction to go through.
So, of course, everybody's coming up short when they sell the house.
Absolutely. Okay. And in a short sale, the seller does not get any funds. They walk away with nothing, but they get to walk away. And for a lot of people who either need to move, lost their jobs, retiring, they need to do a short sale, and they can't wait until the magical moment when the real estate market turns around.
Right. Now, in terms of making this happen, I know when I represent buyers on a short sale, I have a hope and a prayer that the listing agent and the seller are working as a team with the lenders involved. And there might be two lenders, right?
Right. Yeah, that's always a problem because, first of all, short sales, as you know, take a great deal of time because the short sale has to be presented to the lender, and then the lender has to take a look at the short sale and see if it's in their best interest. If you have more than two lenders, then each has to go through the same process. And what I've found out, at least recently, is usually people get into the short sale time frame when they're forced to do something because a foreclosure has commenced. And we'll talk about that in a minute. But when a foreclosure starts, there's a very finite period of time before the property is actually sold, rough and dirty about 110, 120 days. So during that time when the foreclosure may be moving forward during that time period, the seller is trying to sell the property in a short sale. And what I've seen recently is a couple of instances where the foreclosure is marching on while everybody's working on the short sale. But you have to understand, in some of these bigger banks especially, the short sale department is not necessarily talking to the foreclosure department.
Right, you mentioned that before the show.
So the foreclosure folks are doing what they need to do, which is to get the property in the name of the bank or sell it to a third party who may bid over what's owed on the bank note. And the short sale folks have a totally different outlook. They're trying to get more money on the short sale and not go through the foreclosure process. If they're not talking to one another, sometimes everybody thinks they're moving towards short sale, and all of a sudden the property goes into foreclosure and the property's gone. I think it's as a real estate agent, I think the seller listing agent needs to make sure that the two departments in the bank are talking to one another, so you don't get into a situation where you think you're going into a short sale and you find out at the last minute that the property's disappeared by foreclosure.
Right. And that's what we have spoken with Project Sentinel, their team, the nonprofit, and they had mentioned that families would come in with their paperwork and the staff would be looking at the paperwork and realize the home was repossessed last week.
Right.
And they are still living in the home.
Sure.
So that brings up a good point about that short sale department and the foreclosure department. So there's a team perhaps in a building in one state, and there's a team or another county working on the foreclosure. And the left hand doesn't know what the right hand's doing.
That's very often the case because some of these big banks are huge in terms of the number of people they employ. And you've got so many foreclosures going on and so many short sales that I think they're starting to get their arms around it, but a couple of years ago it was so chaotic. It was hard to keep track of these things.
Now, as a real estate professional, I could have services that I subscribe to where I could look up a property and they have post a little red flag that there's foreclosure activity, that a notice of default has been filed at the courthouse. Mm-hmm. So now I know the time is running, the clock is running on that property.
Right.
For instance, I did not do that on a property the other day. A buyer wanted to see some homes. We met at one and I called the realtor and she said, we have a sale date coming up. So I'm on the property, showing the house. I'm talking to the realtor on my cell phone, and the listing agent, the seller's agent, says we have a sale date, October 6th. And now, so that, can you speak about that? That's on the courthouse steps?
Well, yeah, the property has to be sold on the courthouse steps by statute, and a trustee appointed by the bank is going to auction the property off to the highest bidder. Mm-hmm. And it's usually, not always, but usually the bank bidding in the full amount of their loan, or maybe an amount less than the full amount of their loan, and then they'll end up with the property. But when I was talking about the foreclosure folks and the short sale folks, the foreclosure people can postpone that foreclosure.
Exactly.
And that's what they need to do, to see if the short sale is going to be successful.
Right.
And when they don't do that, and they're marching toward that deadline, that 110 to 120 day deadline, you get the problem with the left hand doesn't know what the right hand's doing. They don't postpone it and the property disappears.
Right. And that's what I was leading up to. I can't tell you how many listing agents, realtors working for the seller, tell me we need a sale now so we could stop the foreclosure process. So that's, they're hoping that we get an offer so that they can go the long way around the barn. They have to go through that short sale department.
Yeah, and there's other ways to approach it. They're more expensive, but you could, if you had a legitimate sale, in other words, a contract with a qualified buyer with no contingencies, and you had that sale moving toward close of escrow, you could go into court and get a temporary restraining order on the sale of the property to finish it out.
Wow.
That seems to me excessive and expensive when all you need to do is get the foreclosure department talking to the short sale department. And
there's really just the seller and the listing agent are the two main people to make that happen.
Right, but usually the listing agent will take the lead to talk to the bank because the seller may feel uncomfortable, the seller may feel this is what I'm paying the listing agent to do, so he or she should do it.
There's another good point. I've been attending these conferences on short sale distressed properties, and the people that are on the panel are the top people at these banks. And they all mention that sellers are willing to cooperate in the first days and weeks of the process. But once you go down week, month 3 or 4 or 5, getting their tax returns or their updated paycheck stubs, that's problematic. So do you see in your practice where you're trying to complete a sale and one spouse is not helpful or one seller is dragging their feet?
Well, I don't sell real estate, so I only see the problems.
The disputes.
When the wheels come off. But I know in especially contentious divorces, you can get a situation where one doesn't want to cooperate, just to sort of, the get even notion in that. And I have heard about that, and it's hard because if you don't cooperate with the bank, then the bank has no incentive to cooperate with you. If they don't get the information they're looking for, if they don't get the financial statements and all of what they're requesting, then they're going to refuse to do the short sale, and then you're stuck with the other alternatives that you have available, and they're not, for the most part, very pleasant ones.
Okay, so for the seller, when they are in a short sale, they have to provide a loan package even larger than when they bought the house. Is that right?
Yeah, and a financial package, because if you remember during the halcyon days of loan making in the 2005 and a couple of years beyond that, you had a lot of loans that were made with no documentation whatsoever, stated income loans. So the borrower did not supply tax returns and pay stubs or anything like that. And now they have to do it in order to qualify for the short sale. And the interesting thing, and this has come up in my practice before, I always say to people, when the bank requests that financial information, you better make sure that if you had a non-stated income loan, that you gave in the financial information, they better be pretty close, because there's issues of fraudulent loans. Loans were made on financial information which was a little sketchy, shall we say?
Right.
And so if the bank looks at that and says, wait a minute, 3 years ago when he got this loan, he said he was making $150,000 a year. Now he's telling us he's making $35,000 a year. What gives? Was that a fraudulent loan to begin with that maybe a loan broker was involved in, or there's something funny going on? Then you expose yourself to potential issues of fraud, criminal liability. So you got to be really careful when you do that. I always tell people, if it was on the up and up when you started, you give them the financial information now, don't worry about it. But if there's anything going on, we need to talk about that.
Okay. Now, the alternatives to short sales.
There are a few. There is something called a deed in lieu of foreclosure, which I used to say they're about as scarce as unicorns. But I've actually done a couple of deeds in lieu of foreclosure in the last year. I've done, I think, 3 of them. And what that means is you say to the lender, and the lender agrees, look, I don't want to go through the short sale process, and I don't want to go through the foreclosure process. So you just sign the deed to the property over to the bank. The bank accepts it because they have to sign off on it too. And then you transfer the property, you move out, and it's not your problem anymore. The reason that they're not really common, I believe, is that if you have a second lien on the property, for instance, you deed the property back to the first lien holder. Now they get stuck with the second lien because it's an encumbrance on the property. So that a lot of times they don't want to do that. The deed in lieu of foreclosure that I've done, they've been, usually a typical deed is a 2-page. The deed in lieu of foreclosure, you might say 5 or 6 pages about if you defrauded me in anything, if you've got liens that are undisclosed and haven't actually attached to the property. There's a whole laundry list of things that the bank wants to cover, that if they're going to take this deed in lieu, that they're not going to get stuck with something that they don't want.
Now, on a deed in lieu, does that go through an escrow process? Or is it just between the seller and the attorney and
It's usually between the bank and the attorney. You want to have a title company involved. The bank does anyway, because they want a policy of title insurance on that deed in lieu usually. So that's one thing that you could do as a deed in lieu. That's pretty much a long shot.
Okay.
The second one is you could try to do a loan modification, and those were really popular, say 3 years ago. We had loan modification questions coming to us on a daily basis. We actually did a couple of loan modifications for clients, and we found out what a bunch of work it is.
Sure.
And so we decided we weren't going to do it. But the loan modification process is intensely frustrating because a lot of the banks don't want to do the loan modifications to begin with, but the feds would like them to do that to keep the people in their houses. But the banks are looking at it from an economic standpoint. So the bank wants a loan modification package, and you give them all the documentation. And repeatedly, when I used to hear this, I used to think that people were just grousing, but I hear it from almost anybody who does loan modification. You give the package, you wait maybe 3 weeks, and you call the bank and you say, I've sent this loan modification package in. Have you got it? What do you think? And they'll say, okay, what was your name again? And they say, well, we don't have any record of that. And so you redo the whole thing.
I've heard a lot of that.
Yeah, you send it in again, and you wait another 3 weeks or maybe a month, and they say, well, we haven't processed it yet. And you go 3-4 months, and you call them up again, and they'll say, you know, you're lost in the system. We don't know really where this is. We've lost it. Please resubmit again. And by that time, you're at the point where you just want to shoot yourself. So either you give up or you keep down along that process. But the loan modification process can take a tremendous amount of time. And it doesn't make much sense to me because usually during this process, the borrower is not making payments to his lender. You know, he's not making payments whatsoever. So to drag this thing out 6-10 months doesn't make any sense from the bank standpoint, but that's typically what happens.
So part of the loan modification, they could take the arrears, all the past due amounts, and put it on the end of the loan, right? Forbearance, that's one tactic?
Yeah, what we've seen in loan modifications, a lot of them come out costing the homeowner more than he was paying before, because they tack on that additional principal and they want to increase the principal balance of the loan. And they're not giving you a big enough break on the interest rate. And so you end up saying, I can't make that payment either because you want to do it on 15 years versus 30.
Wow.
So it doesn't work for me. So it's been primarily a process that's been very exasperating, and I don't think very successful for the most part. Then the other things that borrowers can do, they can just simply let the house go into foreclosure, which I would counsel against doing it if you have other alternatives, because it's really a hit on your credit for one thing. And most credit agencies and lenders or anybody who's going to extend credit to you look at that as sort of the kiss of death. It'll knock your credit score down about 150 points.
Wow.
So you can do much better if you do a short sale, which is what we've been talking about. The other thing you could do that we were talking about out in the hall before we got in here was the concept of bankruptcy. Now, once you jump into bankruptcy or file for bankruptcy, then the law recognizes something called the automatic stay. And what that means is that anybody that's trying to collect a debt from you, a lender, a credit card company, must stop and cease all activity because you're in bankruptcy. And then you're going to either liquidate out in a Chapter 7 bankruptcy, or you're going to do a reorganization under a Chapter 13 bankruptcy. But it stops the lender from proceeding with foreclosure. Now, it won't last that long because the lender has some tools they can use to try to jump that thing back out of bankruptcy. Right. But you'll buy yourself some additional time, and during that additional time, what I see people doing is they're strategizing is, how long can I stay in this house using the various techniques available to me that I don't have to pay?
Right.
Because I'm going to put that money in the bank because I've got to move someplace when I lose this house. And then I'm eventually going to want a down payment for another house somewhere down the road. And you're probably seeing this, I don't know if you do this at all, but the rental rates on residential properties have jumped dramatically because the housing stock is down, so it's supply and demand, and rental houses are commanding a much higher price than they did a few years ago.
Right, and I saw that in the last recession. By the way, the S&L crisis, real estate fraud there as well. They didn't want to do a deed in lieu of foreclosure because they didn't want to get the word out. They didn't want to encourage people to walk away from their houses.
Sure.
Yeah, it's a little different recession there, but
well, what's happening right now is the opposite of that is happening. People don't want to walk away; they want to stay in as long as they can.
That's a good point.
And even after the bank forecloses on the property, sometimes they don't get around to actually securing the property and getting access to the property for a while, especially if they're really busy with these things.
Okay, by the way, that's another point with when a short sale, typically we don't have the electronic realtor key safe on the porch. It's now by appointment only, do not disturb occupants, 24-hour notice. It's impossible to show some of these properties. So that might be a tactic too to delay the process.
Oh, sure.
Okay.
That's right. But again, if you've got that foreclosure process moving through the pipeline, you've got a drop dead date, an absolute date that something has to happen unless it's postponed. If you got real activity in a short sale, that'll postpone it. Right. If you've got nothing more than people are just sort of hanging around waiting for the gavel to fall, then you're going to march forward to the foreclosure, and they'll eventually be put out in one way or another. And one of the things that the banks have decided to do is, the bank gets a piece of paper that says they're now the owner. That's a trustee's deed that gets recorded in the real property records. But you still have living human beings in that house.
Right.
So how do you get them out? You can file a lawsuit to get them out, and then they'll try to play the game of seeing how long they can stay in. So the banks have decided that it's much easier to approach the people in the house and say, what is it going to take to get you out? I'll pay you some money if you leave. And I don't know what the going rate is, but I know that the banks are giving what's called cash for keys. You give me the keys to the house, promise not to come back in, and I'll give you cash, and you have to be out on a date certain. That solves the problem. It gives the borrower who's lost his house some money, and it gets the bank some surety, some certainty rather, that they're going to get the house without having to go back to court, get an eviction, and go through that process.
Right, and home might be in better condition.
Right.
So,
although I've heard stories, and I haven't confirmed them in my own practice, but that people are so upset that they're losing their homes that they just trash the home. They go through the home, They put big holes in the sheetrock, they throw cement down the toilet and the plumbing fixtures to muck that up and then walk away. That's not a very smart idea, because under the deed of trust that you signed when you got that loan, it says that if you commit waste on the property, in other words, you try to destroy the property or make it less valuable, that's on you.
Right.
So people doing that may not know that the lender could chase them for any money that they have to spend to fix the property.
Well, there has been some district attorneys around the state that have been going after homeowners that trash their property.
Well, I think it's good.
Yeah.
I don't think that's right.
By the way, when there is somebody's not making their mortgage payment and they're in a planned unit development or homeowner association, they really need to make that HOA payment.
You bet. I had a case this year where and I don't know how this happened, but the bank had foreclosed on the property. But then the bank didn't take possession or record their deed for a long period of time. And during that interim, the HOA fees are continuing to run.
Sure.
So my client came to me and said, I have 6-8 months worth of HOA fees, which were pretty hefty, and I don't want to pay them. The bank's got the property, let them pay them. And I said, well, I have some bad news for you. Those HOA dues are actually a personal obligation that'll run with you when you leave that property, and they're your obligation to pay. And the bank doesn't pick up those HOA dues until they actually record that deed and take possession of the property. And they hadn't done that in this case, so he was liable for the HOA dues. And my experience is the HOA does not want to negotiate. Everybody thinks everything is negotiable. HOAs typically don't.
No.
They want their full payment.
Right. And before the slowdown happened, they were already in financial tricky waters. That most homeowner associations did not have enough cash.
They did not have anything in reserve, probably.
Right. And so this really hurt them. So it's really counterproductive for somebody that's trying to do a short sale and not pay their HOA, because it's going to make the new buyer, it's going to be a lot tougher to get a new loan when the banks look at the financial condition of that homeowner association.
Absolutely right.
Yeah.
Yeah.
So we spoke about, and I've seen you speak about this at your seminars, the tax ramifications compared to the last recession, that a homeowner would lose their, do a short sale and or sell short and write a check to the bank to leave the house, and then they get a 1099 in the mail for mortgage debt relief.
Sure. Well, let's discuss the first part about the lender, because what was going on until fairly recently is a lender would, if they wanted to do a short sale, they'd have you sign up and say, you're going to pay me some cash in addition to what we're going to accept when we do the short sale. If you balk at that, they're going to say, I'm not going to do the short sale. Or they'll say, we reserve the right to seek a deficiency against you. I mean, it vacillated when I first started looking at these. I got the banks to say, we agree that we will not seek a deficiency judgment. They'd put that in writing. I'd say, well, then you're okay, because they said it so in writing. Then they said, we're not giving that anymore. We're going to reserve our rights.
All right, there's a while.
And so the client would say, well, what do I do? And I said, well, I don't know, because the lender is not telling you they won't, and they're not telling you they definitely will, but they have certainly reserved the right to chase you around. So you got to be careful if you're going to sign that short sale letter with the lender. But in January 1 of this year, the California legislature passed some legislation that says that if a first lien holder does a short sale, they are not entitled to a deficiency. They can't ask for a deficiency after the fact. Well, that helped for only a little bit, because what happened is the problem with short sales was the second lien holder. Because the second lien holder usually was going to get nothing. Right. Or a pittance. So the second lien holder would want to reserve their rights to chase that borrower. So the legislation that was passed didn't really solve the problem. So on July 15th of this year, the legislature in California passed new legislation that says the anti-deficiency language on a short sale applies to first lien holders, second lien holders, third lien holders, no matter how far down you are in the food chain. If you've got a deed of trust that secures money that was obtained with regard to that property, none of them can seek a deficiency judgment. I think that's going to help the short sale sellers a lot, because it takes out the ambiguity about whether the lender can actually chase the borrower for a deficiency judgment. Now it's very clear, the law has made it very clear.
So it was a triple whammy. They would be losing their house or losing their equity. Then they could get hit for the loss to the bank. When the bank came up short, they could give it to a collection agency, and then they could get a 1099 in the mail for the mortgage debt relief.
The good old 1099-C. Yeah. And it's really funny, because I explained to people the way this thing works. The government takes the position, the IRS does, that if you don't have to pay for something, you've had relief of indebtedness, and that's income to you.
Exactly.
But now there's a law that was passed in 2007. It sunsets in 2013. It's called the Mortgage Debt Relief Act of 2007. And it basically says that you don't have that income.
We agree that's a great thing for the homeowners.
I agree.
Okay. Well, can you stick around for another show?
Sure.
Okay. Thanks again for watching Kapowich on Real Estate. This is a program dedicated to consumer protection within the residential real estate arena. We will see you next week, same time, same channel. Thanks for watching.